लक्ष्मी नारायण भाला जी हैं, इन्होंने अभी अभी हम लोग को ज्वाइन किया है। दादा नमस्ते, आपका भी बहुत बहुत स्वागत है। और इसी के साथ हम सत्र की शुरुआत करते हैं। एंड टुडे आवर फर्स्ट स्पीकर इज श्री विक्रमजीत बनर्जी सर. Vikramjit Banerjee, the Additional Solicitor General of India, and earlier he was Advocate General of Nagaland State. Sir, we welcome you, and now it's over to you, sir.
Thank you. It's a great honor to make a presentation before Justice Dave and Justice Lahoti, and of course, it's always a pleasure to appear before the faculty of the Delhi University, and every one of them is so very close to me. My presentation, which I'm going to make, is in some ways a short presentation. It is a presentation which is going to deal with the conflict of the terms of religion and dharma in the Indian Constitution. And I would endeavor to put forward few questions before this webinar as to how the courts have sort of handled the entire conception of religion, and how there needs to be a more nuanced understanding of the conception of religion based on the broader conception of dharma, or dharma, however we use that word. Now, I'll start from the very beginning. I think it's very important to discuss the entire question from the very beginning. What are the two major provisions of the Indian Constitution? And that is where this entire conflict, seeds of this conflict lies. The first is Article 25, which talks about your right to freedom of conscience, profess, practice, propagate, and of course, subject to public health and public order and restrictions. And of course, the restriction on 25 is subject to further restriction in 25(2), which says that changes could be made by the state for secular activities and for social welfare purposes. So that's an individual right, and that's what I'm going to come back later on. It's an individual right. Now, Article 26 is a right which deals with the right of religious denominations and subject to public order, morality, and health. Right of religious denominations to manage their own affairs. That's broadly the right. Now, there is Article 27 also, which deals with the right that no one is going to be taxed. There's going to be no religious taxes. 28 is no one is going to receive religious instructions. And Article 30, which deals with religious minorities, which we will not deal for the present moment because that leads to a different line of discussion completely. But most importantly, and the crux of it, and this is what I would be the sort of subtext of all my talk, is that Article 25 talks about individual rights. So every person has an individual right, a right which against the state. Article 26, and this is unique. I think there are very few rights like this in the Constitution. And I think this right itself is extremely unique across the board for various different constitutions. And I'll sort of mention a few of them. Wherever rights are not given individually, and this is not like Article 30, a minority protection. This is a group right which is given in the Constitution. So Article 26, which gives a right to religious denominations, actually provides you a group right. Now, both these rights are against the state. And both these rights are based on a conception, and at what Savita ji discussed right at the beginning, is based on a conception of entitlement. That is, a person or a group is given a right which they have a right to exercise against the state. But it's very important to note that our religious formulation in the Constitution, what a religious right is in the Constitution, is very different from what exists outside in different other constitutions in different other countries, because we have a group right which supplements our individual rights. Now, what is the crux of difference between 26 and 25, 14, 19? The crux is, on one side, there is a right to a group to exercise whatever it feels, whatever are its own rituals, however it wants to manage its own affairs. And on the other side, and the rest of the constitutional rights, which we are all so aware of, 14, 15, 19, even 25, are individual rights. So eventually, because of this nuanced, or I would say either a unique formulation or a strange formulation or a nuanced formulation, however much we try to classify it, it leads to a conflict between groups and how they manage their groups, and individuals as to how they, whatever they perceive is whatever is their claim against the state. I would say this, and as we all know, this is the crux of the conflict between which lies at the base of Sabrimala. What is the right of a religious denomination versus what is individual rights? Individual rights can be Article 25. Individual rights can be Article 14. Individual rights can be Article 15. There can be so many individual rights. Now, my answer to this being at the core of the conflict of religion in Indian Constitution is that the Indian Constitution, as we all know, is in effect consists of two parts. It consists of a 1935 Government of India Act formulated by the British, which is the power controlling document superimposed by this unique fundamental rights chapter, which revolutionizes our constitution, which is what demarcates our constitution and makes it different from other constitutions in the world. Now, it was our attempt at the end of the freedom struggle of 200 years to create a modern state. And I say this very consciously, and this is something which we all must realize, because people at the time of framing of the Constitution realized this, but today, after 70 years, we seem to have forgotten this, is that to create a modern state in a civilization which went through maybe for 5,000 years. So we existed in a society which was which had a conception of faith, which has a conception of belief, which had a conception of social stratification, which had very, very different conceptions. And we were trying to create a modern state out of that. So in dealing with this very complex situation on the ground, our Constituent Assembly tried to address the realities of India by taking a very nuanced step as to how to deal with the complexities which arise in front of us. Now, as an aside, this was unique because, as anyone is aware of the history of other very big complex constitutional states, maybe something like, for one example, America literally started off with the tabula rasa. They started off 200, 300 years ago, completely new, started the state from scratch. Two, in Britain, where there was a gradual process of the formulation of the relation between church and state and what is your religious right and what is not. It was the basis of a number of small struggles which led up to the formulation of even the right to religion, because all of us know Catholics were not allowed to vote, Jews were not allowed to vote even a few years back. Even today, at the very day today, there are reservations in House of Lords for the Church of England, for seating, for voting and for voting purposes on certain issues. Now, in France, it was the approach was that you destroyed the old state completely. You destroyed it completely. You made it irrelevant. You destroyed all the old religious structures, and you created a new constitution, a new formulation. South Africa, you arrived at a complex compromise between different groups on small levels to ensure that no group dominates the other. But it's only in India. And this is what is extremely interesting, and this is what is unique about the Indian experiment, was you created, or you tried to create, a modern state, an effective working modern state over a civilization which is 5,000 years old. You created a democracy. You created, for the want of a better word, a democracy, a republican democracy, a democracy which works on and made it the basis of fundamental rights. So you gave people fundamental rights, and you put in structures in place, which is unlike maybe possibly China or the old Soviet constitution, whereby you formulated a system which would govern the state in future, which would take into account both the complexities of a modern state as well as the real life challenges of a 5,000-year-old civilization. Now, the crux of the problem is this, that, as Swami Vivekananda, I'm very fond of quoting Swami Vivekananda most of the time. So as Swami Vivekananda very interestingly stated, is that our people, and he stated in a different context, our people understand faith more than they understand politics. Swami Vivekananda, a very interesting observation. He said that in the West, if you have to explain religion, you have to explain it through politics. And in India, if you have to explain politics, you have to explain it through religion. So, he was discussing spirituality, faith. So in India, we had to use, we were in a very difficult situation. We were in a very difficult situation. And it goes to the heart of the formulation of who we are. Because our conception of what is dharma and what is right is what makes us very unique as a society. And across the board, and I would say from Kashmir to Kanyakumari, that's the issue. And from East and West, that's the issue. And that is the core of what is the challenge which we are increasingly facing with the Indian Constitution. Because our social mores, our civilizational mores far predate the Constitution. Our understandings of what is justice, understanding of what is nyaya, understanding of even a controversial thing as what is caste. And this is something which is akin to that question, akin to dharma and akin to religion, which we face today, is what is jati, what is caste. And the fact of the matter is, what is bhasha, what is language? These are questions which go to the heart of the formulation of the Indian Constitution. Because the Indian society understands these issues, and I'm not saying these concepts, but these issues very differently than what modernity does. And for better or for worse, modernity is a product of the West, whether we like it, whether we do not like it, but that's a separate issue. But it is a product of the West. So it comes with Western understandings of uniquely from Western Europe and maybe a little from America of how to govern and how to run the state. So what is the solution to it? This lies at the heart of the conflict. So what is the solution to it? And here is my differences with the court. There is one possible, there are two solutions. I'll address the first and what the court has done, and I'll address what I think it should do in my small, humble suggestion. The court has to address this increasing problem, and this problem is becoming clearer and clearer. Within 70 years, it's become quite clear. I'm sure in 150 years, 100 years, it's going to become even more clearer. that the culture is very different from the institutions of state. The court has tried to take the road recently of transformative constitutionalism. Now, we've heard this being used a number of times. What is the crux of transformative constitutionalism? It was first used, as we all know, in South Africa because of the unique circumstances in South Africa where people wanted to form a state which would no more divide the state between blacks and whites, but create a uniform state. It has now been used in India. It has been used in India broadly to say that we are now, at the day the constitution came into effect, is the day when basically India changed. And we have to use the provisions in the constitution, the virtues in the constitution, to transform people completely. So the constitution is a tool to transform people. Transform this civilization, this society in which we exist. Now, the whole question is, what are the values in the Constitution? The values in the Constitution is, of course, modern values. Who contributes to those modern values in India? And my submission is something which we all need to think about. Is this values is a very urban-centric, well-educated, background-wise, a value which and I'm using these words, with great amount of deference, and I'm not using this word in a pejorative way. A certain section of elites like us, and I sort of include myself in it. Our values are not the values which large amount of people in India hold. This again leads to the other famous debate which we're increasingly facing, is that when you talk about morality, do you talk about public morality, which is there in the Constitution, wordings of the Constitution, or do you talk about constitutional morality? This constitutional morality is again a morality which is interpreted, which is a morality which is intended to make this broader set of people who have different values into modern values. So the whole question is, that is a method, but then which gets you to the broader question is, then leads to the question is, whose constitution are we talking about then? Is it the constitution of the people who operate the power structures of the constitution? Or is it actually a constitution of the people, as the preamble said it is? If it is a constitution of the people, then it should reflect the values and the mores of that of the people. So, so how do we handle this? I would say, and this is my suggestion, and I take inspiration again, the descent in Sabrimala. This entire question arose in context of Sabrimala, which we have all seen. And I think this is my take, that Sabrimala in itself also possibly in some places has an answer to that. One of the answers put forward is, maybe we need to have a cultural constitutionalism, a constitutionalism which is based not so much in transforming people, but actually arises from the culture of the people. Justice Malhotra in her dissent spoke about cultural constitutionalism, that you have to take inspiration from the culture of the people to have a constitution which arises from that. And I think that's the crux of it, because that is how, let's say, a dharmic interpretation would be. A dharmic interpretation, to my mind, would arise from the culture of the people, because it would be discovered dharma exists, is not a law which is laid down. Dharma is not the dictates of the king, but dharma arises from within the people. So for a dharmic interpretation of the right to believe, right to faith, which are all integral parts of dharma, there has to have a constructive interpretation which would need to be holistic in nature, which would need to take into account the views of the people, views of the society, as well as, of course, individual conscience. But it has to have a holistic understanding. Now, this is not new. Again, I'm just reminding you because it's not new. It's not my interpretation across the board. Mahatma Gandhi himself warned us about this. He said, this is the conflict at the heart of your new state which you are creating. He warned us a number of times. And even Swami Vivekananda, and continuously throughout, again, his entire speeches, always talked about that India, modern India is torn between two things, he said, Skilla and Charybdis. On one side is this equality, this limitless freedom of the West, along with Indian spirituality on the other hand. And he says India is constantly torn amongst all this. So I think in our case, as lawyers addressing these issues of religion and dharma, we are also largely torn. Now, when we talk about religion, and in conclusion, I will like to sort of address this. When we talk about religion, we talk about a Western conception of treating people in boxes, which is unlike the way people deal with faith in our civilization. And that is what has led to a large amount of conflicts in how we deal with religion. Now, when religion itself started off with, and all of us who know Roman law would understand this, religion started off something akin to dharma. In fact, religio, as Cicero, the great Roman jurist, said a number of times, religio comes from the word, to hold things together, exactly what dharma means. The dvira dhatu means that to hold things together. Religio also comes from a similar background. But religion develops over a period of time in Western Europe, especially during the conflict between different religions or different interpretations of Christianity during the 16th and 17th century. And religion comes to mean a group of beliefs. What is the group's codification of beliefs? What are the beliefs each and every group holds? And this is the crux of this entire problem when we are dealing with religion in India today, even by the court. Because whether it be in Tilkayat, whether it be in the Anandamargi case, the court tries to test, and even in Sabrimala, the court tries to test that these are the beliefs, core beliefs, and tries to test each and every practice as to whether it is part of that core belief or not. And the history of that, of this entire sort of treating religion, Western conception of religion goes to that, is because when you sort of try to differentiate between who is a Protestant and who is a Catholic in Western Europe, or who is a Jew for that matter, and people came from a similar background with similar religious histories, Jews, Protestant Catholics, and and there were even Unitarians, and different groups and different religious practices, and there were Baptists and Anabaptists and Methodists. So at the end of the day, you decided that these are the core beliefs of this religion. Now, our problem is that the court has adopted that. And I would only suggest, I would say that this is an incorrect test. I have very strong words written in my note, possibly saying that, this is a false test. This is not a correct, but I'm trying to sort of tone it down and say this is an incorrect test, a test which I don't think is in consonance with Indian culture, and I think which has led onto this broader other questions of treating of the conflicts between our civilizational treatment of faith and our modern state system treatment of faith, which has also led to this entire conception of trying to bridge both gaps by using transformative constitutionalism. I think, or for that matter, constitutional morality as a limitation on religion. I think what we need to do is get an interpretation which is more akin to our civilizational values, which I would say would be a more dharmic interpretation, an interpretation which by nature to arrive at, the court needs to explore as to whether this interpretation is widely held, is from within the people. A more constructive interpretation which would hear every voice and which takes into account civilizational values, civilizational mores, cultural values, cultural mores. And which seems to be the crux of the crux of the dissent in Sabrimala. And in conclusion, I would say that it's very, very important and key that we realize this issue and address this issue. Because only time, because we live in very dangerous times. We live in times when these differences can be magnified and can be broadened and can be divisive issues in society. So, and I think both sides hold their views very close to their heart, and rightly. They are both convinced of the correctness of their position. On one side is those people who believe in our civilization and its values, and the other side who believes in modernity and its values. And I think for us, there is a choice that we go our separate paths, and the conflicts become larger and larger and stronger and more vicious, as we are seeing it today happening right in front of us. Or we try to bridge it. And it is here, as I would again say, that the court has to, in some ways, give up its ties and deep felt feelings towards modernity and accept the reality of India. Thank you very much.
Thank you very much, Mr. Vikramjit Banerjee. It was really enlightening. Mr. Banerjee talked about the examples of USA, a country, a great country which started from scratch. United Kingdom, which kept its past, and France forsake its past, its glorious past, I would say, and made a new beginning. What should we do? India, he rightly said, is torn between the two, the old and the new. हमारी हालत कुछ ऐसी है, जिसके पास, जिस सभ्यता के पास एक पुरानी इमारत है, एक पुराना मकान है रहने के लिए, उसका एक भाग सभ्यता का चाहता है कि उस मकान को तोड़ दिया जाए और नया बना लिया जाए. वो तोड़ने में बहुत उत्सुक है, लेकिन अभी नया है नहीं. The new house is only a house of light. It is a house of dreams. दूसरी शक्ति है, दूसरा पक्ष है, वो कहता है कि नहीं, इस पुराने को ही ठोक पीट कर मुरम्मत कर ली जाए. हमारे पास नया कुछ है ही नहीं जाने के लिए, हम पुराने में ही रहेंगे. That is the conflict, and the remedy that Mr. Banerjee has suggested is transformative constitutionalism. How do we transform this old, this great, this vast civilization with modern values? That is really the challenge for all of us, and that is really the objective with which we have initiated this dialogue of this webinar. Thank you very much, sir. Over to Seema ji to invite the next speaker.
Thank you so